I should say hello, first of all, thank you for having me. First thing I should perhaps say is apologies for any noise that you can hear in my background. They're digging up a gas line just outside my house, and they've been doing that for about a week now, so I'm already a bit frazzled. If my room looks dark, it's because I have stacked up duvets and pillows up against the windows, looking like some strange shut-in person, but hopefully I've muffled some of it. But if you do hear some clanking, that's what it is. What I'm going to be doing in this session, relatively briefly, is just galloping through some of the issues that are facing us in employment law, trying to focus on those issues that I think will be of most interest to people involved in reward. What I normally do when I'm starting off a talk about this sort of thing is I look at the government's agenda and I look at the laws that are being proposed and the laws that are in the pipeline. I don't remember a time in my legal career, and I've been doing this subject for about 30 years now, I don't remember a time when there was so little being proposed, or everything seemed to be so much on hold. There was no suggestion in the Queen's speech earlier this year that there was going to be an employment bill this year. There are commitments from the government's manifesto in 2019 that simply haven't been progressed, and I've heard no hint about them at all. There are all sorts of policies left over from the May Premiership involving the Taylor Review. There must have been 40 or 50 proposals that the government accepted at the time, but have not progressed. And the one thing I'd want to highlight, because we've talked about it already this morning, is ethnic pay gap monitoring. And very interesting presentation from Kanisha on that earlier. But in terms of the CIPD calling for that to be mandatory, well, not in a hurry, I would say. The government did consult on this, and they consulted on it more than 2 years ago, and I haven't seen anything come out of that consultation yet. I haven't seen any hint from this particular iteration of the government that it's planning to do anything on that anytime soon. And I think one of the things that did come across from Kanisha's presentation is that this is a much more complicated subject to legislate for than the gender pay gap monitoring. So gender pay gap, the legislation assumes that you know exactly how your workforce divides in terms of men and women, and you know what their hourly rate is, and you can easily work that out, and you produce a very simple and straightforward figure. We could debate how useful that figure is. But with ethnic pay gap monitoring, it's very clear that you can't just replicate that. And gathering the data is an entirely different kettle of fish, and categorizing people according to how you're going to allocate them within that analysis is a different thing. And that's something that you can do if you're working with a consultant on your own workforce and coming up with a sensible way of analysing your ethnic pay gap. And I think that's very important work. But it's an incredibly difficult thing to legislate for every employer with 250 or more employees. And I see no appetite from the government that they're going to legislate for something that complicated. I just can't imagine it happening this side of the general election. The other thing that I thought we might be doing this year is looking at some of the consequences of Brexit, where the government might be deregulating some of the issues that are otherwise were previously controlled by the European Union or were influenced by the European Union. And we've seen no sign of that. There was a rumour of it earlier in the year, but that was quickly scotched by the government, and they seem to have no plans to change anything. So even Brexit has not resulted in any change to the way employment law works. One area that might be looked at, and this is something I'll come back to later on when I look at sex discrimination, is the idea of flexible working and working from home. There were rumours that the government was going to give all workers a right to work from home. They denied that, but the Conservative manifesto does say that a flexible working request, and a flexible working request can certainly cover a request to work from home. The Conservative manifesto says that that will be the default position unless the employer shows a good reason to refuse, and that would be quite a significant change in the law at the moment. It's also possible that we're going to start seeing reasonable adjustment claims for flexible working to accommodate long COVID, right? That's assuming that people who have long COVID are able to establish that their particular condition amounts to a disability. I would have thought that in many cases they will be able to do that where they can show that it's expected that their symptoms will last for more than a year. That's the fundamental test of whether something is a disability or not. So it may be that an employer will be obliged to consider flexible working issues and to consider an adjustment to someone's workplace in order to accommodate that. Everything basically turns on business need. And to be honest, this is the secret to the whole of employment law, right? Employment law is basically about the employer being able to explain why it needs to do what it's done and why what it's done fits its business need. And if you've got a good business case for the thing you're doing, there are one or two exceptions, but by and large, you're well placed in terms of employment law. And that will certainly be the case when it comes to flexible working. One other thing that I've seen mentioned is the idea of paying people differently if they're working from home as opposed to coming into work at the office. I'll leave it to reward colleagues to figure out whether that's a sensible basis on which to reward people. I'll just flag up that there are some contractual issues with doing that. Your contract of employment generally doesn't make it conditional on whether you're coming into the office or not. If you are even on, say, a regional pay differential, if you're on London waiting, that tends to be based on the location of the employer rather than the place where you've chosen to live. And a shift to paying people based on where they've chosen to live, I think, creates some interesting contractual issues. So negotiating it for current employees would be quite tricky. It also potentially creates some equal pay issues if we think that women are more likely to exercise the option to work at home for whatever reason. And I'd have thought that statistically that's probably true. And if that's the case, then an equal pay claim from someone working at home to somebody who's still in the office and is potentially getting paid more, well, let's say that would be an interesting claim. I'd be interested to see how that progresses. So it would be a bold move for an employer to go down that road. One piece of legislation that did crop up and quickly hid again was the exit pay cap for public sector employers. And I'm very briefly mentioning this. I know there are some public sector employers or people who are interested in public sector employment at this conference. That was introduced on the 4th of November 2020 and promptly abandoned on the 12th of February 2021. I have never seen a reverse of government policy as complete and abject as that one was. It was mainly because the regulations themselves were an absolute mess. They were badly drafted, they were unclear, and in particular, they didn't gel with public sector pensions in a way that a cap like this absolutely has to. As I understand it, the government's policy is to reintroduce the cap at some stage. Now that they've got Michael Gove in charge of the Department for Local Government, I wonder whether he would let something as shoddy as the previous regulations go through. I don't know what the timescale will be on that. It may be that the government focuses on individual areas of the public sector and exercises its control to look at exit pay cap payments. I think it would be, again, a bold move for them to actually reintroduce the regulations, but we shall see. Moving on to case law, for most employment lawyers, I think the most significant decision this year has been the Supreme Court's decision in the Uber case. And that decided that Uber drivers are workers. Now, it's important to make clear this distinction. It's very important in employment law that you have employees, and employees, your normal run-of-the-mill employee on your payroll, qualify for all employment rights, including unfair dismissal, maternity leave, redundancy payments, that sort of thing. The UK is quite unusual, borderline unique in the world in having this secondary status for employment of workers. That's people who aren't in a contract of employment, but are doing work as an individual for an employer that qualifies them for certain rights like the national minimum wage, working time regulations, holiday pay, and discrimination rights. And Uber drivers were claiming that they were workers, this secondary category. Previous cases had been all about the contract that they're engaged on. It's been about picking apart the terms of the contract to figure out exactly what category those people would go into. What the Supreme Court did in this case, to cut a very long story short, is it upended our view of how we decide whether people are workers. And what they say instead is you look at the nature of the work that's being done, the nature of the relationship, and you deal with the contract afterwards. And in reality, what that means is it makes it much more difficult for employers like Uber to try to come up with smart aleck ways of drafting a contract so that people are genuinely self-employed, so that people don't qualify for this worker status. We much more cut to the heart of what the relationship is and the reality of the relationship without worrying too much about the particular terms of the contract. And in this case, the key thing that the Supreme Court focused on was the extent to which Uber drivers couldn't act as entrepreneurs, couldn't really act as individual businesses. They were under the control of Uber in terms of how they did their work. They're in a position of subjugation and dependence, and that became entirely clear. One thing that I'll be watching out for in the budget is whether the Treasury manages to make any progress on the taxation issue around workers and employees. Because workers, although they get these employment rights, are very often characterized as self-employed for tax purposes, right? The income tax system doesn't have this employee worker self-employed divide. It just says employed or self-employed. And workers, I would say, usually are categorized as self-employed for tax purposes. And that's a difference in treatment that I think the Treasury has long been uncomfortable with. And in a sense, it justifies the different thresholds in workers' rights, that you have these different taxation regimes. And if you were to solve one, if you were to tax people evenly, it might lead to a more unified system of who gets employee rights in this country. But that's the sort of thing that someone could write a PhD about, and I'm not gonna solve the problem here. But I just flag that up, that that's something that government is likely to be looking at. The other key issue that happened that's relevant to national minimum wage is the case of the Royal Mencap Society against Tomlinson Blake. And this was a case that I think I remember being at an IDR conference 2 years ago talking about this case as being about to be decided. We actually only got the decision in March 2021 because unfortunately one of the Supreme Court justices who was drafting the main judgment actually died, and they had to get someone to take over where he left off. So it took a bit of time to come out. There was a very complicated argument that was being produced about whether someone who's on a sleepover shift, so they're permitted to sleep at work by their employer, should be counted as working for those hours that they're asleep for the purposes of the national minimum wage. And I'm not going to go down the road of explaining what that complicated argument was because the Supreme Court basically dismissed it. They went back to the purpose of the original statute, looking back at a 1998 report from the Low Pay Commission in saying that the clear intention was that when someone works a sleepover shift and they're allowed to sleep at work, only working when they're woken up to deal with a particular emergency, then the time that they're spent nominally sleeping, I think it's clear from the Supreme Court that it doesn't matter whether you're actually unconscious or not, but the time that you're lying in bed not being asked to do any work does not count for the purposes of working time, for the purposes of the national minimum wage. It actually does count for the purposes of the working time regulations, but that's a whole other problem. What that means is that those hours don't count towards the hourly calculation that you make for the national minimum wage. And it means that quite a lot of people who will be working quite intense periods of working during the day, doing a sleepover shift, and then working during the next day, the hours that they're working will actually be rather less than they might feel that they're working, and that can be reflected in the wage that they get. The Supreme Court seemed to be talking about those workers continuing to get paid an allowance for their sleepover shift, and that is the best practice. I would say that workers who are doing a sleepover shift get paid an allowance, but of course the national minimum wage does not require an allowance. There is nothing in the law now that says that people have to get paid an allowance or get paid anything in respect of that time that they spend sleeping, which when you think of the time that care workers have had over the past 2 years, seems like something that government should look at. But again, no sign of that so far. Widening it out and talking about some other employment law issues just quite quickly. One of the things that we're going to be looking at quite a lot, I think, coming out of the pandemic is particular rights that attach to health and safety reasons. So people who are refusing to carry out their work or refusing to go into the workplace because they're afraid of the danger, they have protection against dismissal even if they've got less than 2 years service. This was a case that was slightly different in that the employee was specifically employed to do a health and safety job. He was employed to implement a new health and safety system. And what the employers forgot to tell him was that the workforce he was working with were going to be quite resistant to that, because that was going to be quite a change from the way they were used to practicing. And they wanted to tell him to ease up on it and introduce these changes gently, But they didn't quite communicate that, with the result that he came in like an absolute steamroller, and everybody was incredibly miffed at the way he was managing them. There were lots of complaints from the workforce about this very strident way in which he came in was changing the way they were doing things, and the employer basically chickened out because of that friction. They dismissed him. Now, he is entitled not to be dismissed for performing his health and safety duties, even if he's got less than 2 years service. If the reason he's dismissed is that he was performing his health and safety duties, that's an automatically unfair dismissal. The employer argued, well, the reason for the dismissal here was the friction with the employees. It was the complaints from the employees. It wasn't the activities themselves. The Employment Appeal Tribunal basically say, oh, come off it, you can't make that distinction. The friction was the direct result of the activities and couldn't be separated from them. So anybody who is being particularly strident in their health and safety role has protection if backlash from the employees means that employers take action against them. Getting perhaps more towards pay, or at least collective bargaining and the consequences when collective bargaining goes wrong, we've had an interesting case called Mercer against Alternative Future Group Limited about the right not to be subjected to a detriment for taking part in union activities. Right? This is a right that all workers have. You're entitled not to be subjected to a detriment for handing out leaflets, attending union meetings, doing anything else in connection with your union and being a member of the union, provided that's done at an appropriate time. And at an appropriate time has always been taken to mean at a time agreed by the employer. So the employer might have agreed that you can have a particular meeting at a particular time of the day, or it's outside normal working hours. So handing out a leaflet in the canteen during the lunch break is perfectly okay, but handing out a leaflet while people are actually working is not taking place at an appropriate time. What that has meant is that previously that's completely excluded activities amounting to industrial action. So industrial action itself is not a protected union activity, has previously been the view. But here the allegation was that a striking employee was disciplined by her employer for abandoning the particular shift she was on when she was called out on industrial action. And the Employment Appeal Tribunal held that we had to read the law in accordance with Article 11 of the European Convention on Human Rights, which talks about freedom of association, in particular, freedom to join a trade union for the protection of your interests. And they interpreted that law to mean that, therefore, you've got a right not to be subjected to a detriment for taking part in industrial action. There are separate rules on dismissal that are really quite complicated. And also, I don't think this affects, the court specifically said it didn't affect the deduction of pay for work not done. So if I abandon my work because I'm going on strike, I'm not entitled to be paid for the rest of the shift because I haven't worked the rest of the shift. But that's not a detriment. A detriment would be if I was then disciplined or had some other deduction made from my wages that went beyond the mere not working aspect of things. But it's potentially an important case on just nudging union rights along in line with the European Convention on Human Rights. Our new Justice Secretary, by the way, is very much against the European Convention on Human Rights being part of UK law. So we'll see if there's any change in that over the coming years. I've mentioned flexible working earlier on, and just one thing to flag up on that is that the main way in which flexible working comes into an employment law sphere is not necessarily through the right to request or through issues to do with the pandemic. It's a traditional view, which is the people more likely to claim flexible working are women because they are more likely to have childcaring responsibilities that mean that they have to balance their work and home life in that particular way. The case of Dobson against North Cumbria NHS is essentially saying that, look, it is so well established that women are more likely to have to do this that you really don't need to bring specific evidence of that fact when you're claiming an indirect discrimination claim. So if you are claiming indirect discrimination, which is where you're subjected to a rule which causes a particular disadvantage to people who share your protected characteristics, so a particular disadvantage to women, it's always open to the employer to argue that it's a proportionate means of achieving a legitimate aim, so that therefore there's no discrimination. But you do have to show that it's a proportionate means of achieving a legitimate aim. You've got to work quite hard to do that. What you don't get to argue as an employer at the moment is, oh, well, you know, the fact is we know plenty of men who are doing childcare responsibilities now. This is a very old-fashioned view that women are more likely to need to work part-time than men. The Employment Appeal Tribunal says it is still so true that we don't even need to see specific evidence of it. It's called taking judicial notice of the fact that there is this childcare disparity. So that's something that I think was useful to a lot of employment lawyers dealing with that sort of case, which still goes on. I was actually interviewed by the Times Radio about the most recent case on that, which you may have seen in the press, where someone was awarded £185,000 when she was refused part-time working when she returned from maternity leave. And I was being interviewed as though this was a brand new development in the law. And I had to point out that the earliest example I could find was from 1985. It is not a new claim. It is pretty much a standard form of indirect discrimination. Final sort of specific thing to talk about, the Asda against Breely case in the Supreme Court. This is actually an incredibly complicated equal pay claim, and it's a claim where Asda is facing such a huge potential liability that it's essentially taking every point as far as it can go, I think. So although this was hailed by the union who was backing, or certainly the law firm who's backing the claim, from about 30,000 different Asda workers working in a retail environment, comparing themselves with a warehouse environment, this case established that you could carry out that comparison. You were allowed to compare retail workers with warehouse workers simply by asking, why are the warehouse workers paid differently from the retail people? Is it because of physically where they are? Is it because of the kind of work they're doing? It's clearly because of the kind of work they're doing, so we can do the comparison. The question is whether it's equal work. That hasn't been decided yet in the Asda case. There is still a long way to go in the Asda case. The Supreme Court was actually a little bit impatient with Asda, I think, for taking such a technical point, trying to argue that that comparison couldn't even be made. And in their judgment, they've basically discouraged employers from bringing these technical arguments to the Supreme Court in future. What we need to get to the bottom of in the Asda case is, are these two jobs equal? If they are equal, why is one being paid more than the other? And is it anything to do with sex? Is it anything to do with the fact that most of the warehouse workers are men and most of the warehouse retail workers are women? That's the key question. It may be some years before a tribunal actually gets around to answering the question in the Asda case. Final thing to finish on, just because I'm seeing so much debate about it, this idea of no jab, no job. To what extent can you insist on someone being vaccinated in order to continue working? We don't have any law on this yet. There is a judicial review taking place of the government's mandate requiring it in certain sectors, particularly healthcare. We will see whether that goes anywhere. I suspect it won't. My wife works in the NHS, and requiring people to be vaccinated against various things has been standard for some time. One of the first points I made in this presentation was it all comes back to why you need to do the thing you need to do. If you're an employer and you're looking at requiring people to be vaccinated, what you have to ask is, why am I doing that? And do I have the business case that demonstrates the need for it? It can't just be jumping on the bandwagon. It can't just be being fashionable or responding to a leader's particular views about the importance of vaccination. You've got to be able to demonstrate why your business needs to do this, whether that's through a risk assessment or through a business analysis of how your customers are behaving. And if you've got a good enough justification for doing it, I don't see a legal problem in having that requirement when push comes to shove. But that's something I'll happily take any questions about. I think I've gone 1 minute over, but I hope that's about all. I'll certainly stick around for the end as well if anyone's got any questions on employment law that they want to ask. You can also find me on my website, so if there's something you particularly want to ask, then feel free to email me at darrennewman.co.uk as well. And thank you for having me.